All right, so let's imagine this for a second. Imagine you're a philosopher, right?
Right.
And you spent ages, really carefully putting together this incredibly insightful argument. It's like your intellectual masterpiece.
Okay, I'm picturing it. I'm with you.
Okay, so you've got this brilliant argument, and then someone comes along and just steals it, word for word. They publish it as their own. What have they actually taken from you? What's the real loss here? It's kind of a head-scratcher when you think about it. And it leads us directly to this whole complicated idea of intellectual property.
And, from a historical perspective, it's so interesting that this concern about owning ideas, it isn't something new. It's not just a modern anxiety. It pops up way earlier than you might think, in some pretty unexpected places, too.
Yeah, absolutely. And that's exactly what we're going to explore today, this whole idea of intellectual property. You shared some really fascinating stuff from the Stanford Encyclopedia of Philosophy, and our goal is to really dig into it, the history, the different forms it takes, copyright, patents, you name it. And of course, all those deep philosophical questions it raises, the justifications for it, the arguments against it. I mean, for someone who loves philosophy, this is like a goldmine.
And it's really important to see that this goes way beyond just laws. It touches on some massive philosophical issues like, what does it even mean to be an author? What is creativity? What drives innovation? How should we think about information itself? The Stanford entry lays it all out. It traces how IP developed over time, how it shows up in things like copyright and patents, and then it gets into the philosophical core. The personality-based arguments, utilitarianism, the Lockean perspective, even game theory and the prisoner's dilemma come into play. And importantly, it doesn't shy away from those strong critiques of the whole concept.
Right. And for you, our listener, thinking about all this, understanding these frameworks, the why behind intellectual property, and all the debates surrounding it, it can really change how you see authorship, innovation, and information itself. It's powerful stuff. We're going to map out the major philosophical dividing lines, uncover some surprising historical tidbits, and hopefully give you a much clearer philosophical grasp of this whole intricate world. So, where should we begin? What's the best way to untangle this for a philosophical mind?
Well, since we're talking to a philosopher here, I think starting with the historical roots might be especially illuminating because, honestly, the anxieties about intellectual ownership go way, way back. It's really surprising.
I'm all ears. I mean, the entry mentioned some really early examples. Tell me more about that.
Okay, so picture this. It's 500 BCE. You're in the Greek colony of Sybaris, and chefs are getting year-long monopolies on their unique culinary creations. It's like copyright for food.
Wow. Protecting their intellectual taste buds, literally.
Exactly. I mean, even back then, they understood that a unique creation had value, even something as ephemeral as a dish. It speaks to this really fundamental human instinct to protect and reward ingenuity, long before formal legal systems. And then there was this literary contest in Alexandria around the 3rd century BCE. Vitruvius, the judge, caught these poets red-handed. They were straight up plagiarizing other people's work. They faced trial, were convicted, and publicly shamed.
Wow, they didn't mess around.
No, they didn't. It shows that even without laws, people understood that stealing someone's creative work was a form of theft, some kind of violation of an unwritten code of authorship.
So this idea of intellectual ownership, even in these really basic forms, seems to have been around for a long time.
Absolutely. And the entry points out that even in Roman times, legal experts were already debating the different layers of ownership in a creative work, like who owns a painting versus who owns the physical canvas it's painted on. They were thinking about these things way back then.
That's fascinating. But the entry makes an important distinction, right?
Yeah.
Between these early examples and the development of actual IP systems.
Yes, a crucial distinction. We have to differentiate between royal favors or franchises, which often restricted access to existing work that was already publicly available, and the emergence of true IP systems that were meant to incentivize completely new creations. The former was about restricting, the latter about promoting.
It's like the difference between taking something away from the public and actually encouraging the creation of new things.
Precisely. Philosophically, that shift is huge. Is it about control? Or is it about encouraging progress? So when did these formalized systems aimed at encouraging novelty start to appear?
That's a great question. When did these systems become more established?
Well, the Republic of Florence awarded a patent-like statute to Filippo Brunelleschi, the architect, in 1421, acknowledging his rights to control his invention and even built in an incentive mechanism. But the first real lasting patent system came about in the Venetian Republic in 1474. A century and a half before England got around to it, this Venetian system was surprisingly sophisticated. It recognized the rights of inventors, provided incentives for innovation, set up ways to deal with infringement, and even set time limits on the protection.
Venice was really ahead of its time on this. And then England eventually followed with the Statute of Monopolies and the Statute of Anne.
Yeah,
right?
exactly. In 1624, the Statute of Monopolies in England did away with the practice of granting monopolies on things that were already in the public domain. Instead, they started offering these 14-year monopolies to inventors and authors of new works. Then, the Statute of Anne in 1710 is widely seen as the very first modern copyright law. The text itself is so revealing, lamenting the unauthorized printing of books and emphasizing the need to encourage learned men to compose and write useful books. It gave authors 14-year copyrights with a possible 14-year renewal if the author was still alive.
So the initial drive behind these laws seems very connected to advancing knowledge, right?
Without a doubt. And there's this English legal case, Miller v. Taylor from 1769, that's really interesting from a philosophical perspective. Initially, it upheld the idea that authors have inherent rights to control their work, regardless of any law. Even though this decision was later overturned, it shows that early on, people were already debating. Are IP rights natural rights that come with authorship, or are they just created by law? A very philosophical question.
So it's a long and winding road that's led us to where we are today. But tell me, in our current legal system, what actually counts as intellectual property? What falls under that umbrella?
So, generally speaking, in the Anglo-American system, we categorize IP into copyright, patents, trade secrets, and trademarks. There's also this idea of droits morals, moral rights of creators, which is important in continental Europe.
Okay, so let's break down each one. Let's start with copyright. What does that protect exactly?
Copyright is all about protecting original works of authorship that are fixed in some kind of tangible form. This includes a massive range of things: books, music, art, photographs, architectural designs, movies, maps, even software.
That covers a lot of creative ground.
It does, but there are key requirements. The work has to be fixed in some tangible form, meaning you can see or hear it. It has to be original. It comes from the author, not copied from somewhere else. And it needs some level of creativity or authorship. Interestingly, copyright doesn't usually protect things like short phrases, titles, or names.
And there's also this distinction between utilitarian and non-utilitarian works, right?
That's right. Copyright mostly focuses on what we call non-utilitarian or non-functional expressions, stuff that's more about the art or expression. Things that are made mainly for their function, like tools or machines, might be protected under patent law if they qualify. And here's something crucial for our philosophical discussion. Copyright protects the specific way an idea is expressed, not the abstract idea itself. So someone could read Einstein's theory of relativity and explain it in their own words, and their explanation could be copyrighted.
That's a really important point. It gets to the heart of what creativity really means, right?
Uh-huh.
So what specific rights does a copyright holder actually have?
They basically have 5 exclusive rights. They can reproduce the work, create adaptations, distribute copies, publicly display it, and publicly perform it.
So they have a lot of control over what happens to their work.
They do. And they can even transfer or sell these rights. But it's not forever. In the U.S., copyright generally lasts for the life of the author plus 70 years. For corporate authorship, it's a bit different, but it eventually expires too.
And there are also some limits on these rights, like fair use and the first sale doctrine, right?
Exactly. Fair use allows you to use a bit of copyrighted material without permission for things like criticism, commentary, news reporting, teaching, scholarship, and research. The first sale doctrine says that once you legally buy a copy of a work, the copyright holder doesn't control that specific copy anymore. You can lend a book to a friend or donate it without infringing on anyone's rights. And unlike patents, copyright doesn't prevent independent creation. If 2 people write almost identical poems without knowing about each other, both could get copyright for their own versions.
Okay, that makes sense. So copyright is about protecting expression, not ideas themselves. Now, what about patents? What's the story there?
Patents are about protecting inventions. They cover new and useful processes, machines, manufacturers, or compositions of matter. It's all about the practical stuff.
So more about function than expression, right?
Exactly. There are different types of patents: utility patents, design patents, and plant patents. The most common is the utility patent, which protects new, useful, and non-obvious inventions. Design patents protect the look of a manufactured thing, like the shape of a new phone. And plant patents protect new varieties of asexually reproduced plants. Patent protection is strong. It basically gives the inventor a 20-year monopoly on their invention. No one else can make, use, or sell it without permission.
Wow, that's a pretty strong form of exclusivity.
Yeah.
What are the main criteria for something to be eligible for patent protection?
Generally, there are three big ones. It has to be useful, meaning it serves some purpose. It has to be novel, meaning it wasn't already publicly known or used before the patent application. And it can't be obvious. This means that someone with ordinary skill in that area couldn't have easily come up with the same invention.
So patents reward true innovation. But what does the inventor give back to society in return for this protection? What's the trade-off?
That's a great point. In exchange for a patent, the inventor has to fully disclose the details of their invention to the public. It all goes in the patent application. This public disclosure helps to spread knowledge and allows others to build upon the invention or find ways to invent around it once the patent expires.
So knowledge sharing is built into the system.
Yeah.
But patents do prevent others from making the same invention, even if they came up with it independently, right? That's a key difference from copyright.
Absolutely. And that's a point that sometimes causes debate. All right, moving on. We have trade secrets. Now, trade secrets are a totally different animal.
Okay, tell me more. What makes them so unique?
Well, trade secrets are all about protecting confidential information that gives a business a competitive advantage. This could be formulas, manufacturing processes, customer lists, marketing plans, anything that's valuable because it's secret.
So it's all about keeping things under wraps.
Yes. Unlike patents and copyrights, trade secrets aren't registered with the government. You protect them simply by keeping them secret. If the information becomes public knowledge, you lose that protection.
So it hinges on secrecy, and unlike patents, trade secret law doesn't stop someone from independently discovering the same information, does it?
It doesn't. However, it does protect against misappropriation. If someone illegally gets hold of your trade secret or reveals it, you can take legal action. Trade secret protection can last forever, theoretically, as long as you can keep the information secret.
So forever as long as nobody spills the beans. That's interesting. Okay, lastly, we have trademarks. What are those all about?
Trademarks are all about branding. They protect words, names, symbols, designs, or any combination of those that businesses use to set their products or services apart from others. Think logos, slogans, brand names.
So they're like a badge of identity for a company or product.
That's a great way to put it. They help consumers connect a certain level of quality, reputation, or origin with a specific brand.
And trademarks mainly prevent confusion in the marketplace, right? So you know exactly what you're getting.
Precisely. Trademarks make sure you're not tricked into buying a knockoff. But there's a catch. If a trademark becomes so common that it starts to be used as a generic term for the product or service itself, it can actually lose protection. That happened with the word aspirin.
That makes sense. So trademark owners have exclusive rights to use their mark in commerce, and they can stop others from using similar marks that could confuse consumers. And these rights can theoretically last forever as long as the mark is still being used and they keep paying renewal fees.
You got it.
Okay, so we've now mapped out the legal landscape. Now let's dive into the core of what's interesting for a philosopher. The justifications behind these rights. Why do we have them in the first place? What are the arguments?
The Stanford entry lays out several key arguments. The main ones fall into three big categories: personality-based theories, utilitarianism, and lock-in labor theory. It also looks at a more recent argument based on the prisoner's dilemma. That one is particularly interesting.
Okay, let's unpack these one by one, starting with the personality-based justification. What's the main idea behind this view?
This view, which draws heavily on the philosopher Hegel, basically says that intellectual property is an extension of a person's personality, their talents, feelings, character, experiences, everything that makes them unique. So when they create something, they're putting themselves out into the world.
So it's like their creations become a part of who they are.
Exactly. And this act of creation is seen as essential for self-expression and individual freedom. Think about an artist and their painting. It's not just canvas and paint, it's the artist's vision, their emotions, their unique way of seeing things. To mess with that, to misrepresent it or claim it as your own, is seen as violating the artist's personality, denying their contribution and their identity. It ties in with those moral rights we talked about before, the right to be recognized as the creator, and the right to protect the integrity of your work.
That makes sense, especially when we think about art and creative works. But the entry also mentions some problems with this view, right?
Yes, there are definitely some challenges. Firstly, it's not clear that we own our feelings or experiences the way we own a physical object. Can you really own your feelings? And even if we do, does that ownership automatically extend to the things we create based on those feelings? You could argue that creation is more like sharing a part of yourself with the world. And thirdly, this theory struggles to explain IP rights for more functional creations, where personal expression might be minimal, like a purely functional design for a simple tool.
So maybe the personality argument works better for certain types of IP, like art, but not so much for purely functional inventions.
That's a good point. The entry does mention a response from those who support this theory. They say that even with these objections, there's this strong, intuitive feeling that something's wrong with changing someone's artistic work without their permission or claiming it as your own. You're harming their reputation, and it can even be seen as forcing them to say something they didn't say.
That's a compelling argument. All right, let's move on to utilitarianism. What's the main idea behind this justification for IP?
This one is all about incentive. It's been very influential in shaping IP law. The idea is that by giving creators limited ownership rights, we encourage them to create valuable stuff. If anyone could just copy their work, why bother putting in the effort? So the argument goes, strong IP rights lead to more innovation, which ultimately benefits society as a whole.
So it's a way to maximize social well-being by promoting innovation.
Exactly. The entry cites a bunch of economists and legal scholars who back this up. They say that evidence suggests that IP protection does actually lead to more innovation, encourages creators to share their work publicly, and helps to avoid secrecy and limited markets. Without some way for creators to profit from their work, there would be less research, less creation, and ultimately everyone would be worse off.
But the entry also brings up counter-arguments. It questions the evidence and points out potential downsides.
It does. There's definitely debate about whether IP protection is the main driver of innovation. Some argue that it can actually hinder innovation by making it hard for newcomers to enter a field, by stifling cumulative innovation, and by encouraging people to just sit on their rights and collect royalties without really contributing much. They say that other things, like being the first to market, the inherent joy of creativity, and the availability of supporting services, could be enough to encourage creation even without strong IP rights.
And there are even economists who argue that we might be better off without a patent system altogether.
That's right. Some economists suggest that we might get better outcomes by funding research directly through government grants or by giving rewards for particularly valuable innovations. That way, you get the benefits of new creations without the downsides of restricted access and monopolies. Trade secrets are often criticized from a utilitarian perspective because they protect information without requiring any public disclosure, which means that potentially valuable knowledge can be hidden away.
So, the utilitarian justification comes down to weighing the benefits of more creation against the potential costs of restricted access and maybe even less innovation down the line. It's a tough balancing act.
It is, and those who support the utilitarian view often say that while the current system might not be perfect, it's probably the best compromise we have right now. They also argue that ongoing adjustments can help to find that sweet spot between rewarding creators and making knowledge accessible.
Okay, let's move on to the Lockean justification. This one comes from John Locke's ideas about labor and property rights, right?
That's right. This argument builds on John Locke's theory of natural rights, his idea that people have a natural right to the fruits of their labor. In his book, Two Treatises of Government, he argued that when you work on something, you mix your labor with it, and that gives you a right to own it.
So it's like you're putting a part of yourself into your creation, and that makes it yours.
That's the basic idea. And when you apply this to IP, it means that creators deserve to control what they produce because they invested their time, effort, and skill into making it. It's theirs because they brought it into existence through their own work.
But intellectual works are different from physical things, right?
Yeah.
So you can copy a song 1,000,000 times, and the original is still there.
That's true. Intellectual works are generally considered to be non-rivalrous. One person's use doesn't prevent others from using it too, and they're non-depletable. Making a copy doesn't use up the original. But the Lockean argument says that creators are just claiming a right to control what they brought into being, not depriving others of anything they already had. They made it, so it's theirs.
But Locke also had these provisos, these conditions for acquiring property. Like you have to leave enough in as good for others, and you shouldn't take more than you can use before it spoils. Do those apply to IP?
Right. Well, the non-spoilage requirement doesn't really matter for IP because ideas and creative works don't rot like apples. But the enough and as good proviso is definitely debated. Does me writing a song and keeping it to myself prevent others from writing songs? No. But what about patenting a life-saving medicine and restricting access to it? Does that violate Locke's proviso?
That's a good point. It seems like applying Locke's theory to IP isn't so straightforward. And the entry mentions even more objections, right?
It does. Some critics, like Jeremy Waldron, question the whole idea of mixing your labor with an intangible idea. How can you mix your work with a concept? And others point out that if you build on someone else's intellectual work, shouldn't your labor also create some rights? Plus, some argue that the tools, knowledge, and cultural context that creators rely on are themselves products of society, which weakens the case for exclusive individual ownership.
So there are a lot of holes you can poke in the simple lock-in argument. But the entry also talks about a modified version, a more nuanced lock-in approach.
That's right. This version focuses on the idea that creators have a prima facie claim to control their work because of their effort and investment. It's the starting point. And then they bring in a modified version of Locke's proviso. It basically says that if giving control to the creator doesn't demonstrably harm others compared to the situation before the creation existed, then it's okay to grant that property right.
So as long as nobody's worse off, the creators claim holds.
Yeah.
That's interesting. And the entry also mentions the role of agreements and conventions in solidifying these rights.
Yes. In small communities, creators might rely on direct agreements or social norms to protect their work. In larger societies, IP laws could be seen as a more formal version of those agreements, where everyone agrees to give limited rights to creators in exchange for the benefits of innovation and creativity.
It's like a social contract for ideas. Okay, we've looked at the personality-based, utilitarian, and lock-in justifications. Now, this prisoner's dilemma approach sounds intriguing. How does that work?
This one is different. It's not about inherent rights or direct societal benefit. It's about what's strategically best for individuals with their system. Imagine there's no IP protection. It might seem smart to just copy everyone else's work, right? You get all the benefits without the effort. But if everyone did that, there wouldn't be any new stuff to copy. We'd all be worse off.
So it's like that classic game theory scenario where pursuing individual self-interest leads to a bad outcome for everyone.
Exactly. By having IP rights and enforcing them, we encourage people to refrain from copying, even if it's not always the most immediately advantageous thing to do. Respecting IP ensures that creators are rewarded, which keeps them creating, and we all benefit in the long run. It's recognizing that while free copying seems good now, it ultimately destroys the system that gives us all those valuable things we want.
It's a long-term perspective on the benefits of IP. It's like we're all playing a game, and IP rights are the rules that make sure the game continues.
A great analogy. This perspective can even apply to international relations, where enforcing IP rights globally can lead to more innovation worldwide.
Okay, so we've covered a lot of ground on justifications, but the Stanford entry also looks at some serious critiques of IP rights. It's important to see both sides.
Absolutely. Let's dive into those critiques. One of the most fundamental is the argument that information is not property. What's the reasoning behind that?
This critique challenges the whole idea of treating information like physical property. It argues that ideas, concepts, and creative works are abstract. You can't own them the same way you own a car or a house. They exist beyond the physical world, and many people can use them at the same time without diminishing their availability.
So applying the concept of property, with its ideas of exclusivity and scarcity, to information is seen as a fundamental mismatch.
Exactly. It just doesn't fit, conceptually. Some even argue that the term intellectual property is misleading or just wrong.
But are there any counter-arguments to this strong claim? Does the entry offer any nuance? It does. It points out that ownership itself can be understood in different ways. It doesn't always mean physical possession. It can also be about having the right to exclude others from using something. Even if information is different from a physical object, we can still decide as a society to give creators some control over how their work is used. So even if we don't call it property, we can still have laws that protect intellectual content rights or something like that.
So it's about finding the right language and the right balance of rights. Another major critique centers on the fact that information is non-rivalrous, meaning I can use information without stopping you from using it. What are the implications of this for IP?
This argument highlights a key feature of intellectual works. They can be used by countless people simultaneously without diminishing their availability. If I copy a song or share an idea, the original is still there. So the argument goes, restricting access through IP rights seems inefficient and maybe even unethical. It's better to maximize access to information as it benefits everyone.
It's the knowledge wants to be free argument, right?
Kind of, although there are different arguments there. But in this case, the point is that just because information can be copied freely doesn't automatically mean it should be. The entry uses the example of sensitive personal information. Just because something can be copied endlessly doesn't mean everyone should have access to it.
Right, there are other things to consider, like privacy.
Exactly. And even with non-rivalrous things, unauthorized copying can still harm the creator by impacting their income. So the non-rivalrous nature of information doesn't mean everyone automatically has a right to access it. That right would need to be justified on other grounds.
Okay, that makes sense. And then there's that famous slogan, information wants to be free. Where does that fit into the debate philosophically?
That slogan, popularized by John Perry Barlow, argues that information has a natural tendency to spread freely. He believed that trying to control information in the digital age is pointless and even harmful. But critics point out that information itself can't want anything. Wanting is something that conscious beings do, not abstract concepts. And even if information did want to be free, that doesn't automatically mean we have a moral obligation to let it, especially when you consider all the work that often goes into creating it.
It's a catchy slogan, but it might be philosophically shaky. Okay, now there's also the free speech argument against IP rights. How does that one work?
This argument says that IP laws, especially copyright and patent law, can restrict how we access, use, and share ideas and expressions. And that can clash with our fundamental right to free speech and our right to access information and knowledge.
So it's seen as a potential conflict between protecting expression and promoting the free flow of ideas.
Precisely. The worry is that overly broad or long-lasting IP rights can stifle creativity, shut down critical discussion, and prevent the open exchange of ideas that's so vital for a healthy society.
But those who support IP rights surely have some counter-arguments, right?
They do. One argument is that IP protection actually leads to more information in creative works in the long run, which benefits everyone. They say that creators need incentives to share their work publicly. They also point out that free speech isn't absolute. There are already limits, like laws against defamation or inciting violence. IP rights can be seen as another necessary limit to balance different interests in society. And in copyright law, they emphasize the idea expression distinction. Copyright protects how an idea is expressed, not the idea itself. Anyone is free to build on those ideas.
So it's about finding the right balance between protecting creators and ensuring open access to information. Another critique focuses on the social nature of information. What's that all about?
This view emphasizes that all intellectual works build on pre-existing knowledge, culture, and innovations. No one creates in a vacuum. We all draw on ideas, tools, and traditions that have been developed and shared over time.
So it's like we're all standing on the shoulders of giants, so to speak.
Precisely. And because of that, giving exclusive ownership to individuals can be seen as problematic. It's like giving someone ownership of a public bridge just because they laid the last brick. This argument says that since the building blocks of IP are created and shared by everyone, individual ownership should be limited.
But there are arguments against this social nature critique, right?
Of course, some, like Lysander Spooner, question how society can own ideas it didn't create or pay for. They also point out the problems in defining what society even means in this context. And they argue that individuals already contribute to and benefit from this shared intellectual heritage through education and access to public domain works. They worry that this argument, taken too far, could undermine the recognition and reward for individual creativity.
It's a complex issue with valid points on both sides. Now, the entry also mentions some specific critiques related to the cost of publishing digital information and a broader liberty objection to IP. Can you tell us a bit about those?
Absolutely. The cost of digital information argument basically says that in the digital world, where copying is so easy and cheap, the old justifications for IP weaken. Why charge high prices for digital information when it costs almost nothing to distribute? But this overlooks the fact that creating high-quality content still requires a lot of upfront investment research, writing, design, etc., and a fair price is ultimately determined by the market.
So it's not just about the cost of copying, but also the cost of creation.
Exactly. And the liberty objection argues that IP rights go too far in restricting individual freedom. They go beyond the limits of traditional property rights. They say that IP laws interfere with what people can do with their own property, like making copies of things they own or sharing books, and that they limit our freedom to use ideas. But those who defend IP often point out that there are already limits built into the system, like fair use. And they argue that all rights, even property rights, have limits. We can't just do whatever we want with our property if it harms others.
It seems like every argument has a counter-argument. This is a seriously complex issue. So having gone through all this, what are the key takeaways for our listener, especially for someone approaching this as a philosopher?
The most important thing to remember is that IP is not a simple topic with easy answers. It's a very complex area with a long and evolving history, a whole bunch of legal mechanisms for protecting different kinds of intellectual creations, and most importantly for a philosopher, a tangled web of philosophical arguments for and against it.
There's no one-size-fits-all answer, right?
Right. The debate about IP goes deep. It forces us to grapple with fundamental questions about what it means to be a person, what is good for society, what justice demands, how we understand information itself, and how to balance the rights of creators with the need for access to knowledge and culture.
It's about as philosophical as it gets.
It really is. And for you, our listener, hopefully this exploration helps you see the bigger picture. It shows how these legal formworks are grounded in deep philosophical questions about what it means to create, to own, to share, and to contribute to our collective intellectual and cultural world. It's a reminder that the tension between individual rights and the common good is always there, and that applying traditional philosophical concepts to intangible creations like ideas is a tricky business.
It leaves us with some pretty big questions.
Right.
Okay?
Absolutely. Here's a big one for you to ponder. If the ultimate goal is for knowledge, understanding, and creativity to flourish in society, are our current IP systems the best way to get there? Are we actually creating artificial scarcity in a realm where abundance might be better? What would a truly philosophically sound approach to owning ideas look like? One that balances the rights of creators with the needs of society and recognizes the unique nature of information. That's a question worth thinking about.
Lots to ponder indeed. Thanks for taking this deep dive with us. It's been a fascinating exploration.
My pleasure. Always a great discussion.